Good morning, you're Nathan Lamel, Senior. And Mr. Lamel was previously in court and entered a plea of true to count 1 in a motion to revoke deferred probation on probation for evading arrest or detention with the use of a vehicle. And that was from February 17th of 2025. Count 1 that he pled to was the count where he was arrested for a burglary of habitation. It was not necessarily that he had committed it, but that he had been arrested for it.
And Judge,
Go ahead.
So you're aware, the motion reads kind of funny that you pointed out to us last time. So I could technically abandon 1 and 2. I just kept them there for your review. I have corrected them in 7 and 8. Believe.
Okay, so
That's
there
why
was a
it's
first amended.
Yes, ma'am.
So we need to go through that first amended.
Correct. And then Ms. Branch will be here to testify in place of Ms. Jefferson if those pleas don't change.
Okay, hold on a second. Let me pull this up correctly. So let's go through that motion. Mr. Lamel, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can put your hand down. And will he waive the formal reading of the first amended motion to revoke unadjudicated probation?
So waived.
So again, and this is 24 DCCR 0826. You have a first amended motion to revoke your unadjudicated probation. Shows you were placed on probation February 17th of 2025 for evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? It alleges you violated your probation, and I'm going to go through the whole thing again, just because I don't have the other one right in front of me. It'll be easier. So count 1 alleges that you were arrested. Okay, so did you want to
Abandon 1 and 2, Judge, and show that they're correctly reflected in the First Amendment 7 and 8 committed.
All right,
That's
so,
what you didn't like the arrested for last time?
well, I mean, arrested for is fine, but it's not a violation
Correct.
of your probation.
Correct.
Okay, so 1 and 2 will be abandoned. So count 3 alleges that you failed to report as directed to the probation department March 5th and April 9th of 2025. And is that true or not true? True or not true?
True or not?
Count 4 alleges that you provided a urine sample May 1st of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true? That's marijuana, THC. Count 5 alleges that you were at a location other than your residence at approximately 3:01 a.m. April 26th of 2025 in violation of your probation. Is that true or not true? Count 6 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that on May 1st of 2025 you tested positive for alcohol. And is that true or not true? Count 7 alleges that you committed the offense of burglary of a habitation April 26th of 2025. And is that true or not true? And count 8 alleges that you failed to avoid injurious or vicious habits and refrain from behavior harmful to others, and that you were aggressive towards both Beaumont police officers and the complainant, Aronia Parkerson, on or about April 26th of 2025. And is that true or not true? Count 9 alleges that you provided a urine sample May 1st of 2025 that tested positive for ecstasy. And is that true or not true?
Your Honor, if I might, I don't think ecstasy is listed in the Controlled Substances Act. It would be MDMA. That's the street vernacular for methylene dioxymethamphetamine.
Okay, so if it's the same thing and it's just another name for it.
But I'm not sure that would be a violation. What would be characterized as ecstasy? If they want to amend to allege MDMA, that would.
Ms. Malfino?
I'll make that oral amendment, Judge, to change ecstasy to reflect MDMA as worded in the Controlled Substance Act.
All right, so any objection to that?
No objection.
All right, so that count 9 alleges now that you provided a urine sample that tested positive for MDMA, which is also ecstasy. Is that true or not true? Did you enter your pleas of true to counts 3, 4, 5, 6, and 9 freely and voluntarily?
Yes, no.
And because they're actually true?
Yes, no.
All right, so with regard to the burglary of a habitation, Ms. Malfino, what is the state's position as far as wanting to, do you want some time to
Judge,
prove that, or?
I will defer to whatever the court would like me to do. The complainant in that case has filed a non-prosecution affidavit and has also indicated to my office that she does not wish to cooperate in that case.
Okay.
I do believe Ms. Branch can testify with respect to that injurious or vicious habits in her reflection or read of the police report if Mr. Kimler wouldn't object. Otherwise, if you would like me to get those officers to detail his behavior on that night, I can do that, but she has not been cooperative with me.
Okay.
Obviously, Your Honor, I would like the opportunity to cross-examine if the state does attempt to prove it up. I would just observe that whatever conduct Mr. Lamel did engage in didn't result in criminal charges being filed to the level of resisting or harassment or anything of that nature, retaliation.
So we already did the updated pre-sentence report, and the recommendation in that report, it was unagreed, and the recommendation at that time was that he would benefit from both tracks of ISF. Can't do both tracks, but go in and do the substance abuse track, followed by JCDI, anger management. Ms. Malfino, since it can't go if the other case is pending, I guess based on what you're telling me about the complainant in the other case, what is your position on that?
To not proceed on that case, Judge.
Okay, so there'll be a dismissal.
If we order him to ISF, I will file a dismissal today so that doesn't hold him up. If that's also Ms. Branch's.
Is that still your position?
Yes, ma'am.
Cognitive track or substance abuse, Your Honor?
Well, substance abuse is clearly an issue. I think I would rather do substance abuse and then JCDI and then whatever other behavioral thinking, moral recognition or something like that once he's out, and so that we get the more intensive substance abuse before he gets out for JCDI would be my thought. What do you or would you think cognitive track would be better? You do? Okay. So what is the status of the relationship with the complainant? What's her name?
I'll represent to the court.
Aronia Parkerson. I'm asking him. I'm asking
I
him.
understand, but she's present outside of the court.
Okay. So what is your status of your relationship? Are y'all still together?
Yes, no.
Do you want to ask her some questions since she's here?
Maybe so, Judge, if I may. I didn't realize she was.
You want to go visit with her for a minute, or do you
She's
want to have her
outside.
brought in?
Oh, we can just have her brought in.
Would you please call the name Aronia Parkerson?
So, drug substance abuse.
If you'll scoot over just a little bit towards your attorney. Ma'am, come right over here. You just come on up right here. Would you please state your name, please?
Ariana Parkinson.
And Ms. Parkerson, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Ms. Malfino?
Thank you. Ms. Parkerson, can you please describe for the court the nature of your relationship with the defendant, Nathan Lamel?
He's my boyfriend.
And is the gentleman in the orange to your left, is that Nathan Lamel?
Yes, ma'am.
Your may the record reflect that the witnesses identified the defendant in this hearing.
The record will so reflect.
Judge, on Saturday, April 26th of this year, at approximately 6:15 in the morning, were officers of Beaumont Police Department dispatched to your home in reference to a burglary call that had been made?
Yes, ma'am.
Can you tell the court about that?
Me and Nathan had got into a disagreement. I really don't recall what the disagreement was about, but the first time they were called, he was trespassed, and the officers explained to me that if I called them back, that the trespass warrant would be voided. I was okay with that because I knew I was going to call him back eventually. But he came back a second time, which made me call them again because he wanted to talk about whatever we had a disagreement about, but I didn't want to at that moment. I was going through a lot. I had just had my son a month prior, so I was dealing with postpartum. And at that moment, I just didn't care to hear what he had to say. But he knew I called the police back, but my dad was also at my house, and my dad wanted to talk to us both to see what the problem was between us, which is why he stayed and he was arrested that night.
At approximately 5 a.m. that morning, or thereabouts, 5:20, were you awake and on the sofa in your living room, I'm sure probably with your new baby?
Yes, ma'am.
And what did you hear going on in your bedroom? Breaking of glass, rustling of things around?
Yes, ma'am.
And tell the court about that. What is it that you observed? Did you observe the defendant coming forcibly into the window of that residence?
I wouldn't say forcibly.
Had you given him permission?
No, but I heard him trying to open the window, and at that point I started recording a video just to get him away once the police was brought back.
Did you feel like that entry into your home was with the intent to possibly assault you based on what had been happening previously that evening and with respect to the nature of y'all's ongoing relationship?
No, ma'am, I don't feel that I was in any harm. He just wanted to talk.
So you don't believe that it was his intention to assault you, or that he could have possibly assaulted you in that scenario there?
No, ma'am.
But you still felt it necessary to contact the police on multiple occasions that night?
I just wanted him to leave. I didn't want to continue to talk about the situation. If he would have left the first time and then came back the next day, we could have revisited our situation. Just like when he was released 3 days afterwards, I think accusation is what it's called. He came back to my home and we talked about the situation, and moving forward, we've been good ever since.
Okay. Is that baby his?
Yes, ma'am.
Okay. And is it true that on May 10th of 2025, on August 7th of 2025, that you came in and gave a non-prosecution affidavit signed with Investigator Troy Robinson of my office, indicating that you did not wish to pursue the burglary charges against Mr. Lavelle?
Yes, ma'am.
And is that what you're telling Judge West here this morning?
Yes, ma'am.
And has he pressured you or made you any promises or coerced you in any way?
No, ma'am. I did this of my own free will.
And do you understand that if those charges are dismissed, they're not going to be refiled?
Yes, ma'am.
And that you are taking your safety with Mr. Lamel into your own hands?
Yes, ma'am.
And are you asking the court to follow any agreement that she decides to make with respect to sending him to some substance abuse treatment, so that hopefully when he gets out, your relationship can be more productive
Yes, ma'am.
and he can help you raise those babies?
Yes, ma'am.
Thank you.
No questions.
Thank you, ma'am. You can go have a seat. Okay. Not a good way to handle that situation, was it?
No, ma'am.
When you hear it out loud, how does that make you feel when you hear out loud what you did that night?
A little disappointed.
Not good for your baby, not good role model, not good for the relationship, and not good to keep you out of jail or prison, right?
Right.
So what I'll do then, based on that and based on her representations and probation's willingness to try to help you so that you can be successful, is I'm going to find that you entered your pleas of truth to counts 3, 4, 5, 6, and 9 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to follow this agreement, or not agreement, I'm going to follow the recommendation, and I'm going to continue you on probation. I am going to extend your probation for 1 year. I'm going to order that you enter and successfully complete the substance abuse track of the ISF program. And then when you're released, your aftercare will be through the JCDI program. You will also be required to follow any other new recommendations or classes with regard to making better decisions, cognitive thinking, things like that. This is all meant to help you be successful. I want to make sure you understand, though, that if you come back here again on another motion to revoke, you're probably not going to get the same. I'm sorry.
I'm sorry. I
Yeah, no, you're not going to get all of this again. Does that make sense? You're likely going to be going to prison, and you could go to prison for up to 10 years You could do that today. I could send you to prison for 10 years just for the violations you've already had that you agreed to, the testing positive and all that. I don't need a new case. I don't need any of that. I can send you to prison today. I don't want to do that. I want you guys to work things out, but you've got to make things where that works in a very productive and non-violent and non-confrontational, sober way. Okay? So, probation will let you know what all, again, that you need to do, but you'll go from here to ISF. Once you get out, you'll be in JCDI. No violations. Okay? All right. Good luck to you, sir. So there's still, our tablets are still messed up. And we only have one? We have two. Oh. Sorry, it's coming. All right, will she waive the formal reading of the motion?
So
Ms. Sanders, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. And so, Ms. Sanders, in cause number 22-39884, I have a motion to revoke your community supervision. Shows that you were placed on probation May 1st of 2023 for the offense of theft of property with previous convictions, and that was a 2-year state jail term that was probated for 5 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of theft of property with previous convictions July 31st of 2025. And is that true or not true?
No, ma'am.
not true.
Yeah, not true.
Count 2 alleges that you failed to provide verification of performing the community services required. Is that true or not true?
Yes, ma'am.
True. Yes, that's true.
Not true.
Count 3 alleges that you're behind in your court-assessed fees as of August 19th, 2025 in the amount of $919. And is that true or not true?
That's true.
Did you enter your pleas of true to counts 2 and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. But I'm going to reset your case for a sentencing hearing and ask the probation department to do an updated report. And we'll need, I guess, some time for witness.
Probably about an hour, Judge.
Okay.
We can do it at 11 o'clock on the news.
Okay, so we'll reset it to where we have about an hour or so for any prove up of count 1.
And she's requesting a bond, Your Honor, although it is a straight probation case.
Has there anything been filed?
Should have been last night. But he filed yet.
Yeah, we're not having any trouble with those. He dropped it down. Sorry.
Make it work better.
Let me make this notation first.
You get out if she doesn't read all of it.
Mr. Smith, what is your position with regard to a bond?
State's opposed to bond, Judge. We're seeking state jail time and the new offense as well as.
Speak up, please.
The state is seeking state jail time in the new offense as well as the MTRP.
Okay, let me look at something and then I'll. I should be able to go back and see. Yep. Oh, I'm going to take a look at the original precedence report. That'll just help give me some information about history and what got us here in the first place. No, that's denied at this point. This is her 1, 2. She's on probation for her third felony and now allegedly committed her fourth. So that's denied. We'll get it set for a sentencing hearing and take care of it on that date.
Yes,
You can
Your
go
Honor.
back with the bailiff.
Okay, go back.
Unagreed, yes, ma'am. Good morning, you're Traylon Hill. And this is cause numbers 24 DCCR 1500, 1614, 1615, and 25 DCCR 0436. And Mr. Matusko, what is the announcement on Mr. Hill's cases?
Your Honor, I believe I have all the discovery. Nothing has changed as far as a rejection.
Okay.
We'd ask the case be placed on the trial docket.
All right, then we will get that done at the first available trial docket and get it taken care of as quickly as possible. I understand that when it comes up, it may or may not be the oldest one, but based on the behavior and what the jail.
It was green.
Good morning, you're Roderick Randall. And this is cause number 24 DCCR 0543. And Mr. Randall was previously in court, entered pleas of true in a motion to revoke probation, pled true to counts 1, 2, 4, 5, and 7 and 8 on probation for the first degree felony offense of aggravated robbery. And I've received the pre-sentence report update. Have you all had an opportunity to review that?
We have, Your Honor.
I have, Your Honor.
Are there any additions or corrections?
No, Your Honor.
Well, Judge, I noted probation's opinion that continuing on probation may not be a good idea. And I know we'd agreed on ISF and an attempt to keep him from being revoked. I understand if the court feels differently.
I didn't know that that was an agreement, and if it was, I show that you are asking for that, but I didn't think
And
the state.
I think what I
that
stated was I wanted to see the PSI
Yeah,
and get an idea of what has
The
really
new-
happened or not happened on probation.
well, he pled true, on probation for a case, an aggravated robbery that involved shooting out the window of a car at someone after having stolen stuff from that person. New offense, pled true to being arrested for unlawful carrying a weapon and evading arrest or detention. So, I'm not inclined based on, you make argument, Mr. Rojas?
Yeah, Judge, and my understanding was that it wasn't agreement for ISF, but and if it wasn't, then obviously the court can do whatever the court feels is appropriate.
Can you look, pull up that paperwork? What was the date of, it's not finalized, so the plea paperwork should still be somewhere on the tablet.
August 26th.
If you can get 826 pulled up, do you know how to do that? And send it to me, send his paperwork to me, please. And if that's what y'all's understanding and you need some time to prepare for a hearing, I can reset it for a couple of weeks, if you want to do that as well. But let's see what the paperwork said first.
I think we discussed it, and I said I want to wait and see what PSI says. Let's double check.
Okay.
It is marked off on an agreed punishment recommendation, ISF cognitive, but it doesn't say wait or anything like that, but I don't know that I'm inclined to do that. What is the status of, Are those cases down in misdemeanor court?
They're still pending, Judge. He's been appointed, Mr. Cole, to be his attorney, and I talked with him about that yesterday. He's inclined to go down and plead those cases once this is all taken care of.
I would like to know, at least see a PC on that new arrest.
I
If you
right
have
here,
it, you do?
Yes, sir.
Any objection to me
No objection.
doing that? No. On probation for an aggravated robbery. And if I recall, I don't know that it was ever on, when I tried to go back and see, nobody really said or could tell for sure who shot out of that car that night. But if I'm correct, I feel like Mr. Randall, who was in the back right passenger, was potentially, it was out of the back.
Judge, I feel like because I remember this case, there was four individuals in the car.
Did
I
anyone?
don't think I would have lowered his to a non-aggravated if I believed that he was the shooter in that case.
They did gun residue, Judge, and there was no gun residue on Mr. Randall's hands.
Because it is a non-aggravated robbery, is what it is,
Okay,
what he's on probation for.
but
He was in the
still
car.
in, I mean, still in out of other, breaking into vehicles and,
Multiple vehicles.
yeah. No. And then here we are, May 3rd, so less than a year after being placed on probation, riding around, smoking pot with a gun, and when you got taken out of the car, ran from the cops. No. Go ahead, you can make argument.
Judge, my intention, he is the father of a young child, I think he's a 3-year-old? 9-month-old child at home, Judge. He is obviously making some bad decisions in his life, going all the way back to the original offense date. And that is why I thought ISF would be maybe helpful to him to give him some information to help him redirect his life, make better decisions in his life for himself and for his daughter. He's a pleasant human. Every time I go talk to him, he's a really nice, pleasant to deal with. He's never had any blow-ups here in court that I can recall. He's had maybe some jail incidents. I think he threw some soap around one time and some wardrobe incidents. But other than that, I think he's been well behaved in jail. I would ask the court that if ISF is not going to be possible in this case, that you consider doing something towards the lower end of the punishment range. I don't know that. And again, Judge, I think that's why I think ISF would be better for him. We can send him to prison right now for whatever amount of time, but if he doesn't get the help and the education that he needs, he's gonna come out and be the same way, even worse. So,
Judge, I'm sorry to cut you off, Mr. Ross. I'm showing that 2 new cases were received last week by my office concerning the exact same UCW and evading from July 13th, which is not alleged in the motion. If we need to amend to add those, or if you want to address those.
Another arrest?
That's what I'm showing, Your Honor. Two more pending, not yet filed misdemeanors for evading,
This is May 3rd.
a different offense date. So if we want to take some time so I don't have a probable
Absolutely.
cause available to me,
Yes.
but I can get that, obviously. If we could take a week or so to file an amendment.
Let's go ahead. I'll probably, just based on, court schedule, I'm going to, I want that back.
Yeah, sure.
I'll, let's reset it about 3 weeks. And if there is in fact a new arrest, I would like that.
Certainly.
In the
What I'll
motion.
do is file an amendment to reflect any new offenses or charges, Judge.
Yeah, that'll change everything potentially. So yeah, let's see where we get with that. Go back with the bailiff. You probably need to talk to hey, Mr. Randall, also, you need to talk to Mr. Rojas. You need to tell him everything that's going on. He doesn't need to be surprised here in court. If you've been arrested again for something, y'all should be talking about that.
Thank you.
Thank you, Mr. Nichols. I got a new one on this eye, and it's not, I can see paper, but I can't see my computer. And are we going, okay, we're going on more.
1, 2, 3.
Thank you. Let me get that pulled up properly. Are you Julian Garcia?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
he will, Your Honor.
Mr. Garcia, in cause number 25, DCCR 1392, you're charged with the state jail felony offense of burglary of a building from June 26th of 2025. The indictment alleges you were previously convicted of theft of property, a state jail felony, February 5th of 2016, and that after that was final, you were convicted of unauthorized use of a vehicle, May 5th of 2022. And how do you plead to that charge? And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
I do.
Let's see. So the agreement's for 10.
He was recently sentenced in drug court to a 10 years.
And for the rest of
Okay.
the
The most he's received in the past, Judge, has been several state jail sentences and a 5-year term.
Okay, all right. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Garcia is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty, and also find those prior convictions true. Sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That will run concurrently with cause number 25, DCCR 0767. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, sir. You can go back with the bailiff.